Republic Act No. 9745. An act penalizing torture and other cruel, inhuman and degrading treatment or punishment, and prescribing penalties therefor. Be it enacted by the Senate and House of Representatives of the Philippines in Congress assembled. Section 1. Short title. This act shall be known as the Anti-Torture Act of 2009. Section 2. Statement of Policy. It is hereby declared the policy of the state. A. To value the dignity of every human person and guarantee full respect for human rights. B. To ensure that the human rights of all persons, including suspects, detainees, and prisoners are respected at all times, and that no person placed under investigation, or held in custody of any person in authority, or agent of a person authority, shall be subjected to physical, psychological, or mental harm, force, violence, threat, or intimidation, or any act that impairs his, or her free will, or in any manner demeans, or degrades human dignity. C. To ensure that secret detention places, solitary, incommunicado, or other similar forms of detention, where torture may be carried out with impunity, are prohibited. And D. To fully adhere to the principles and standards on the absolute condemnation and prohibition of torture, as provided for in the 1987 Philippine Constitution, various international instruments to which the Philippines is a state party, such as, but not limited to, the International Covenant on Civil and Political Rights, ICCPR, the Convention on the Rights of the Child, or, CRC, the Convention on the Elimination of All Forms of Discrimination Against Women, or, CEDAW, and the Convention Against Torture and Other Cruel, Inhuman or Degrading Treatment or Punishment, or, CAT, and all of the relevant international human rights instruments to which the Philippines is a signatory. Section 3. Definitions. For purposes of this Act, the following terms shall mean. A. Torture refers to an act by which severe pain or suffering, whether physical or mental, is intentionally inflicted on a person for such purposes, as obtaining from him, or her or a third person information or a confession, punishing him, or her for an act he, or she, or a third person has committed, or is suspected of having committed, or intimidating or coercing him, or her, or a third person, or for any reason based on discrimination of any kind, when such pain or suffering is inflicted by, or at the instigation of, or with the consent, or acquiescence of a person in authority, or agent of a person in authority. It does not include pain, or buffering arising only from, inherent in, or incidental to lawful sanctions. B. Other cruel, inhuman and degrading treatment or punishment, refers to a deliberate and aggravated treatment or punishment, not enumerated under Section 4 of this Act, inflicted by a person in authority, or agent of a person in authority, against a person under his, or her custody, which attains a level of severity causing suffering, gross humiliation, or debasement to the latter. C. Victim, refers to the person subjected to torture, or other cruel, inhuman and degrading treatment or punishment, as defined above, and any individual who has suffered harm as a result of any act, or acts of torture, or other cruel, inhuman and degrading treatment or punishment. D. Order of battle, refers to any document, or determination made by the military, police, or any law enforcement agency of the government, listing the names of persons and organizations that it perceives to be enemies of the state, and that it considers as legitimate targets as combatants that it could deal with, through the use of means allowed by domestic and international law. Section 4. Acts of torture. For purposes of this Act, torture shall include, but not be limited to, the following. A. Physical torture is a form of treatment or punishment inflicted by a person in authority, or agent of a person in authority, upon another in his, or her custody that causes severe pain, exhaustion, disability, or dysfunction of one, or more parts of the body, such as 1. Systematic beating, head banging, punching, kicking, striking with truncheon, or rifle butt, or other similar objects, and jumping on the stomach. 2. Food deprivation, or forcible feeding with spoiled food, animal, or human excreta, and other stuff or substances not normally eaten. 3. Electric shock. 4. Cigarette burning, burning by electrically heated rods, hot oil, acid, by the rubbing of pepper, or other chemical substances on mucous membranes, or acids, or spices directly on the wound, or wounds. 5. The submersion of the head in water, or water polluted with excrement, urine, vomit, and/or blood until the brink of suffocation. 6. Being tied, or forced to assume fixed and stressful bodily position. 7. Rape and sexual abuse, including the insertion of foreign objects into the sex organ, or rectum, or electrical torture of the genitals. 8. Mutilation, or amputation of the essential parts of the body, such as the genitalia, ear, tongue, etc. 9. Dental torture, or the forced extraction of the teeth. 10. Pulling out of fingernails. 11. Harmful exposure to the elements, such as sunlight and extreme cold. 12. The use of plastic bag, and other materials placed over the head to the point of asphyxiation. 13. The use of psychoactive drugs to change the perception, memory, alertness, or will of a person, such as: 1st. The administration or drugs to induce confession, and/or reduce mental competency. Or, 2nd. The use of drugs to induce extreme pain or certain symptoms of a disease. And, 14. Other analogous acts of physical torture. And, b. Mental, or psychological torture, refers to acts committed by a person in authority, or agent of a person in authority, which are calculated to affect, or confuse the mind, and/or undermine a person's dignity and morale, such as: 1. Blindfolding. 2. Threatening a person, or persons, or his, or her relative, or relatives with bodily harm, execution, or other wrongful acts. 3. Confinement in solitary cells, or secret detention places. 4. Prolonged interrogation. 5. Preparing a prisoner for a show trial, public display, or public humiliation of a detainee or prisoner. 6. Causing unscheduled transfer of a person deprived of liberty from one place to another, creating the belief that he, or she shall be summarily executed. 7. Maltreating a member, or members of a person's family. 8. Causing the torture sessions to be witnessed by the person's family, relatives, or any third party. 9. Denial of sleep, or rest. 10. Shame infliction, such as stripping the person naked, parading him, or her in public places, shaving the victim's head, or putting marks on his, or her body against his, or her will. 11. Deliberately prohibiting the victim to communicate with any member of his, or her family. And, 12. Other analogous acts of mental, or psychological torture. Section 5. Other cruel, inhuman and degrading treatment or punishment. Other cruel, inhuman, or degrading treatment, or punishment refers to a deliberate and aggravated treatment or punishment not enumerated under Section 4 of this Act, inflicted by a person in authority or agent of a person in authority against another person in custody, which attains a level of severity sufficient to cause suffering, gross humiliation or debasement to the latter. The assessment of the level of severity shall depend on all the circumstances of the case, including the duration of the treatment or punishment, its physical and mental effects and, in some cases, the sex, religion, age and state of health of the victim. Section 6. Freedom from torture and other cruel, inhuman and degrading treatment or punishment, an absolute right. Torture and other cruel, inhuman and degrading treatment or punishment as criminal acts, shall apply to all circumstances. A state of war or threat of war, internal political instability, or any other public emergency, or a document or any determination comprising an order of battle, shall not and can never be invoked as a justification for torture and other cruel, inhuman and degrading treatment or punishment. Section 7. Prohibited detention. Secret detention places, solitary confinement, incommunicado or other similar forms of detention, where torture may be carried out with impunity, are hereby prohibited. In which case, the Philippine National Police, or PNP, the Armed Forces of the Philippines, or AFP, and other law enforcement agencies concerned, shall make an updated list of all detention centers and facilities under their respective jurisdictions with the corresponding data on the prisoners or detainees incarcerated, or detained therein, such as, among others, names, date of arrest and incarceration, and the crime or offense committed. This list shall be made available to the public at all times, with a copy of the complete list available at the respective national headquarters of the PNP and AFP. A copy of the complete list shall likewise be submitted by the PNP, AFP, and all other law enforcement agencies to the Commission on Human Rights, or CHR, such list to be periodically updated, by the same agencies, within the first 5 days of every month at the minimum. Every regional office of the PNP, AFP, and other law enforcement agencies, shall also maintain a similar list for all detainees and detention facilities within their respective areas, and shall make the same available to the public at all times at their respective regional headquarters, and submit a copy, updated in the same manner provided above, to the respective regional offices of the Commission on Human Rights. Section 8. Applicability of the exclusionary rule, exception. Any confession, admission or statement obtained as a result of torture shall be inadmissible in evidence in any proceedings, except if the same is used as evidence against a person or persons accused of committing torture. Section 9. Institutional protection of torture victims and other persons involved. A victim of torture shall have the following rights in the institution of a criminal complaint for torture: a. To have a prompt and an impartial investigation by the Commission on Human Rights, and by agencies of government concern such as the Department of Justice, or DOJ, the Public Attorney's Office, or POW, the PNP, the National Bureau of Investigation, or NBI, and the AFP. A prompt investigation shall mean a maximum period of 60 working days from the time a complaint for torture is filed within which an investigation report, and/or resolution shall be completed and made available. An appeal whenever available shall be resolved within the same period prescribed herein. b. To have sufficient government protection against all forms of harassment, threatened or intimidation as a consequence of the filing of said complaint or the presentation of evidence therefor. In which case, the state through its appropriate agencies shall afford security in order to ensure his, or her safety and all other persons involved in the investigation and prosecution, such as, but not limited to, his, or her lawyer, witnesses and relatives, and c. To be accorded sufficient protection in the manner by which he, or she testifies and presents evidence in any fora in order to avoid further trauma. Section 10. Disposition of writs of habeas corpus, amparo and habeas data proceedings, and compliance with a judicial order. A writ of habeas corpus, or writ of amparo, or writ of habeas data proceeding, if any, filed on behalf of the victim of torture, or other cruel, degrading, and inhuman treatment or punishment, shall be disposed of expeditiously, and any order of release by virtue thereof, or other appropriate order of a court relative thereto, shall be executed or complied with immediately. Section 11. Assistance in filing a complaint. The Commission on Human Rights and the POW shall render legal assistance in the investigation and monitoring, and/or filing of the complaint for a person who suffers torture and other cruel, inhuman, and degrading treatment or punishment, or for any interested party thereto. The victim or interested party may also seek legal assistance from the Barangay Human Rights Action Center, or BRRAC, nearest him, or her, as well as from human rights non-government organizations, or NGOs. Section 12. Right to physical, Medical and psychological examination. Before and after interrogation, every person arrested, detained or under custodial investigation, shall have the right to be informed of his, or her right to demand physical examination by an independent and competent doctor of his, or her own choice. If such person cannot afford the services of his, or her own doctor, he, or she shall be provided by the state with a competent and independent doctor to conduct physical examination. The state shall endeavor to provide the victim with psychological evaluation, if available under the circumstances. If the person arrested is a female, she shall be attended to preferably by a female doctor. Furthermore, any person arrested, detained or under custodial investigation, including his, or her immediate family, shall have the right to immediate access to proper and adequate medical treatment. The physical examination, and/or psychological evaluation of the victim, shall be contained in a medical report, duly signed by the attending physician, which shall include in detail his, or her medical history and findings, and which shall be attached to the custodial investigation report. Such report shall be considered a public document. Following applicable protocol agreed upon by agencies tasked to conduct physical, psychological and mental examinations, the medical reports shall, among others, include a. the name, age, and address of the patient or victim. b. the name and address of the nearest kin of the patient or victim. c. the name and address of the person who brought the patient or victim for physical, psychological, and mental examination, and/or medical treatment. d. the nature and probable cause of the patient or victim's injury, pain and disease, and/or trauma. e. the approximate time and date when the injury, pain, disease, and/or trauma was, or were sustained. f. the place where the injury, pain, disease, and/or trauma was, or were sustained. g. the time, date, and nature of treatment necessary. And h. the diagnosis, the prognosis, and/or disposition of the patient. Any person who does not wish to avail of the rights under this provision may knowingly and voluntarily waive such rights in writing, executed in the presence and assistance of his, or her counsel. Section 13. Who are criminally liable. Any person who actually participated, or induced another in the commission of torture, or other cruel, inhuman and degrading treatment or punishment, or who cooperated in the execution of the act of torture, or other cruel, inhuman and degrading treatment or punishment by previous or simultaneous acts, shall be liable as principal. Any superior military, police, or law enforcement officer, or senior government official, who issued an order to any lower-ranking personnel to commit torture for whatever purpose, shall be held equally liable as principals. The immediate commanding officer of the unit concerned of the Armed Forces of the Philippines, or the immediate senior public official of the PNP and other law enforcement agencies, shall be held liable as a principal to the crime of torture, or other cruel or inhuman and degrading treatment, or punishment for any act or omission, or negligence committed by him, or her that shall have led, assisted, abetted or allowed, whether directly or indirectly, the commission thereof by his, or her subordinates. If he, or she has knowledge of or, owing to the circumstances at the time, should have known that acts of torture or other cruel, inhuman and degrading treatment or punishment, shall be committed, is being committed, or has been committed by his, or her subordinates, or by others within his, or her area of responsibility and, despite such knowledge, did not take preventive or corrective action either before, during or immediately after its commission, when he, or she has the authority to prevent, or investigate allegations of torture, or other cruel, inhuman and degrading treatment or punishment, but failed to prevent or investigate allegations of such act, whether deliberately or due to negligence, shall also be liable as principals. Any public officer or employee shall be liable as an accessory if he, or she has knowledge that torture, or other cruel, inhuman and degrading treatment or punishment is being committed, and without having participated therein, either as principal or accomplice, takes part subsequent to its commission, in any of the following manner. A. By themselves profiting from, or assisting the offender to profit from the effects of the act of torture, or other cruel, inhuman and degrading treatment or punishment. B. By concealing the act of torture, or other cruel, inhuman and degrading treatment or punishment, and/or destroying the effects or instruments thereof, in order to prevent its discovery. Or, C. By harboring, concealing, or assisting the escape of the principal, or principals in the act of torture, or other cruel, inhuman and degrading treatment or punishment, provided that the accessory acts are done with the abuse of the official's public functions. Section 14. Penalties. A. The penalty of reclusion perpetua shall be imposed upon the perpetrators of the following acts. 1. Torture resulting in the death of any person. 2. Torture resulting in mutilation. 3. Torture with rape. 4. Torture with other forms of sexual abuse, and, in consequence of torture, the victim shall have become insane, imbecile, impotent, blind, or maimed for life. And, 5. Torture committed against children. B. The penalty of reclusion temporal shall be imposed on those who commit any act of mental or psychological torture resulting in insanity, complete or partial amnesia, fear of becoming insane or suicidal tendencies of the victim due to guilt, worthlessness or shame. C. The penalty of prison correctional shall be imposed on those who commit any act of torture resulting in psychological, mental and emotional harm other than those described 1 and paragraph B of this section. D. The penalty of prison mayor in its medium and maximum periods shall be imposed if, in consequence of torture, the victim shall have lost the power of speech or the power to hear or to smell, or shall have lost an eye, a hand, a foot, an arm or a leg, or shall have lost the use of any such member, or shall have become permanently incapacitated for labor. E. The penalty of prison mayor in its minimum and medium periods shall be imposed if, in consequence of torture, the victim shall have become deformed or shall have lost any part of his or her body other than those aforecited, or shall have lost the use thereof, or shall have been ill or incapacitated for labor for a period of more than 90 days. F. The penalty of prison correctional in its maximum period to prison mayor in its minimum period shall be imposed if, in consequence of torture, the victim shall have been ill or incapacitated for labor for more than 30 days but not more than 90 days. G. The penalty of prison correctional in its minimum and medium period shall be imposed if, in consequence of torture, the victim shall have been ill or incapacitated for labor for 30 days or less. H. The penalty of arresto mayor shall be imposed for acts constituting cruel, inhuman or degrading treatment or punishment as defined in Section 5 of this Act. I. The penalty of prison correctional shall be imposed upon those who establish, operate and maintain secret detention places, and/or effect or cause to effect solitary confinement, incommunicado or other similar forms of prohibited detention as provided in Section 7 of this Act where torture may be carried out with impunity. J. The penalty of arresto mayor shall be imposed upon the responsible officers, or personnel of the AFP, the PNP, and other law enforcement agencies for failure to perform his, or her duty to maintain, submit or make available to the public an updated list of detention centers and facilities with the corresponding data on the prisoners or detainees incarcerated or detained therein, pursuant to Section 7 of this Act. Section 15. Torture as a separate and independent crime. Torture, as a crime, shall not absorb, or shall not be absorbed by any other crime or felony committed, as a consequence, or as a means in the conduct or commission thereof. In which case, torture shall be treated as a separate and independent criminal act, whose penalties shall be imposable without prejudice to any other criminal liability provided for by domestic and international laws. Section 16. Exclusion from the coverage of special amnesty law. In order not to depreciate the crime of torture, Persons who have committed any act of torture shall not benefit from any special amnesty law or similar measures that will have the effect of exempting them from any criminal proceedings and sanctions. Section 17. Applicability of refouler. No person shall be expelled, returned or extradited to another state where there are substantial grounds to believe that such person shall be in danger of being subjected to torture. For the purposes of determining whether such grounds exist, the Secretary of the Department of Foreign Affairs, or DFA, and the Secretary of the DOJ, in coordination with the Chairperson of the Commission on Human Rights, shall take into account all relevant considerations including, where applicable and not limited to, the existence in the requesting state of a consistent pattern of gross, flagrant or mass violations of human rights. Section 18. Compensation to victims of torture. Any person who has suffered torture shall have the right to claim for compensation as provided for under Republic Act No. 7309, provided that in no case shall compensation be any lower than 10,000 pesos. Victims of torture shall also have the right to claim for compensation from such other financial relief programs that may be made available to him or her under existing law and rules and regulations. Section 19. Formulation of Rehabilitation Program. Within 1 year from the effectivity of this Act, the Department of Social Welfare and Development, or DSWD, the DOJ, and the Department of Health, or DOH, and such other concerned government agencies, and human rights organizations, shall formulate a comprehensive rehabilitation program for victims of torture and their families. The DSWD, the DOJ, and the DOH, shall also call on human rights non-government organizations duly recognized by the government to actively participate in the formulation of such program that shall provide for the physical, mental, social, psychological healing and development of victims of torture and their families. Toward the attainment of restorative justice, a parallel rehabilitation program for persons who have committed torture and other cruel, inhuman and degrading punishment shall likewise be formulated by the same agencies. Section 20. Monitoring of compliance with this Act. An oversight committee is hereby created to periodically oversee the implementation of this Act. The committee shall be headed by a Commissioner of the Commission on Human Rights, with the following as members: the Chairperson of the Senate Committee on Justice and Human Rights, the respective chairpersons of the House of Representatives Committees on Justice and Human Rights, and the minority leaders of both houses or their respective representatives in the minority. Section 21. Education and Information Campaign. The Commission on Human Rights, the DOJ, the Department of National Defense, or DND, the Department of the Interior and Local Government, or DILG, and such other concerned parties in both the public and private sectors shall ensure that education and information regarding prohibition against torture and other cruel, inhuman and degrading treatment or punishment shall be fully included in the training of law enforcement personnel, civil or military, medical personnel, public officials and other persons who may be involved in the custody, interrogation or treatment of any individual subjected to any form of arrest, detention or imprisonment. The Department of Education, or DepEd, and the Commission on Higher Education, or CHED, shall also ensure the integration of human rights education courses in all primary, secondary and tertiary level academic institutions nationwide. Section 22. Applicability of the Revised Penal Code. The provisions of the Revised Penal Code insofar as they are applicable, shall be supplementary to this Act. Moreover, if the commission of any crime punishable under Title 8, that is, crimes against persons, and Title 9, namely, crimes against personal liberty and security, of the Revised Penal Code is attended by any of the acts constituting torture and other cruel, inhuman and degrading treatment or punishment as defined herein, the penalty to be imposed shall be in its maximum period. Section 23. Appropriations. The amount of 5 million pesos is hereby appropriated to the CHR for the initial implementation of TILS Act. Thereafter, such sums as may be necessary for the continued implementation of this Act shall be included in the Annual General Appropriations Act. Section 24. Implementing Rules and Regulations. The DOJ and the Commission on Human Rights, with the active participation of human rights non-governmental organizations, shall promulgate the rules and regulations for the effective implementation of TILS Act. They shall also ensure the full dissemination of such rules and regulations to all officers and members of various law enforcement agencies. Section 25. Separability Clause. If any provision of this Act is declared invalid or unconstitutional, the other provisions not affected thereby shall continue to be in full force and effect. Section 26. Repealing Clause. All laws, decrees, executive orders or rules and regulations contrary to or inconsistent with the provisions of this Act are hereby repealed or modified accordingly. Section 27. Effectivity. This Act shall take effect 15 days after its publication in the Official Gazette or in at least 2 newspapers of general circulation. Approved, November 10, 2009. Prepared by Taunton of PHILIPPINE, who inspires, and keeps the spark. Thank you for listening.